Okay, so last time we looked at a mediation, right? And today we just need to finish up our mediation unit by talking about mandatory mediation. The system, as we know, likes settlements, and there's been a large push on for the last 20 or 30 years at least to try to get parties to some kind of consensual resolution for all the good reasons we talked about why it's generally in parties' interest to reach some kind of resolution. So the system took note of the fact that mediation works. It demonstrably produces settlements in cases that would not otherwise settle, and chose to make it mandatory, which is why we have Rule 24.1. Interestingly, there's no logic to the numbering, right? Like, this is Rule 24.1. You might think it has something to do with Rule 24. Rule 24 is actually dismissal of action for delay. So it's one of the particular charms of the rules of civil procedure, that the numbering has no logic whatsoever. And you've already gotten used to like the multi-level 0.1, open bracket, close bracket, square bracket, 4 different numbering systems. That actually is there because whenever they add something, they don't want to renumber everything, because all the old, warhorse litigators are used to thinking about a certain rule as being, well, that's my Rule 24, I've got my tab binder on that. And if you renumbered it when you added new stuff, then they would all get confused and rebel. So instead, they cram new things in with the logical numbers, like 24.1. Not that it matters. Anyway, so this is 24.1. And it provides for mandatory mediation and specified actions in order to reduce cost and delay in litigation and facilitate the early and fair resolution of disputes. Okay, so one interesting thing about this is 24.1.11, that the parties themselves, as well as the lawyers that the parties are represented, are required to attend the mediation unless the court orders otherwise. So this is kind of interesting, right? Because normally you don't have to show up personally. That's one of the reasons why parties hire lawyers, is to have someone conduct civil litigation on your behalf. You don't have to show up for your own motions. You don't have to show up for, you don't have to draft your own pleadings. So why do you think it is that we are requiring parties to attend personally along with their lawyers? Yes. So giving lawyers instruction is a big part of it, right? We know from last time that some mediations are positional, right? There's parties basically fighting over some resource or especially money. And if you are a lawyer and you've been instructed that by your client on what your resistance point is, your client says, do not pay more, or I'm not willing to pay more than X, or I'm not willing to accept less than Y, then those are your instructions, and you can't change that, right? Because it would be unethical to settle for anything which is not in that zone your client is authorized. So if the client is there, the client can give new instructions and authorize the lawyer to settle on a different level. Basically, the client can change the resistance point. If the client weren't there, then mediation, then that would be impossible. But as your answer also reflected, it's also true from this point of view, right? If we're doing interest-based facilitated dispute resolution, and we're trying to understand what's really making these parties tick, what their deeper interests are, the lawyers often won't know those things, right? Because you've got to bear in mind that 98% of the time, people think of their lawyer in litigation as their gladiator, as their champion who wades onto this field and does battle on their behalf. So what they share with the lawyer tends to be their positions, right? And they tell the lawyers why they think they're entitled to what they want and what the facts are. And then with the lawyer, they come up with that legal position, which is encapsulated in the pleadings. So if we're trying to do interest-based dispute resolution and find the overlapping area of consensus where the parties' interests are reconcilable with each other, and the lawyer doesn't know what those interests are, then this is impossible. If you get the client there, then have that conversation that gets at those interests. Think of the Miko and Gigan, right? The special chemistry lawyers, right? The lawyers didn't know anything about, the the commercial interests of these parties, or this great deal they might end up doing. If the clients hadn't been there, that would have been completely impossible. Okay, so another thing to look at here that we've already talked about from the quiz question is this. The fact that mandatory mediation is imposed only in these three places. City of Ottawa, City of Toronto, and County of Essex, which we're sitting in at the moment. So this is kind of weird. You know, there's not too many other laws that are passed by the legislature of Ontario that sort of single out specific areas and change your civil rights and obligations based on what city you happen to be in. Any ideas why we're singling these places out? One other possibility is that it just has to do with local culture, like in like local litigation culture, kind of the reality of the way these rules are drafted is the rules are drafted by these rules committees, which are basically controlled by the judges. And if like the chief regional senior judge in Windsor is into mediation and the chief regional senior judge in London thinks mediation is BS, then it's a pretty good chance that they're going to get their way, right? They'll have the committee draft the rules such that the people who want to do it have it, and those who don't are exempted. But anyway, it's an interesting little quirk, and we may be on our way to getting it rolled out across the province. Okay, so you had a couple of short cases here about mandatory mediation. And the first one is Owen versus Hiebert. So this was from back in the day when it was still sort of just beginning to be rolled out. And so it's described as a pilot project there. Hiebert is an employee of Owen's corporation. They became romantically involved, they moved in together, and they were engaged to be married. But then, as a result, the court says in paragraph 3, of alleged economic, emotional, psychological, and physical abuse by the plaintiff, the defendant moved out of the plaintiff's residence in February of 1999. Okay, so they're co-workers, employee-employer, and also living together. Then they break up. Owen sues Hiebert, saying basically she stole his stuff and his furniture. And then she counterclaims against Owen, seeking $200,000 as general damages for sexual assault, indecent assault, and other torts, as well as $100,000 in punitive damages. Okay, so superficially, this is an employment termination dispute and kind of a theft of property dispute, but arguably it's really a family law case, right? And a domestic violence case at the core, kind of wrapped in this shell. So what does this have to do with mandatory mediation, and why does the defendant, Cheryl Hiebert, want an exemption from mandatory mediation? Yes.
She claims so she wants this exemption under Rule 24.105 because she's concerned, she underwent a lot of therapy, and she's concerned that all the progress she's made through therapy will, like, she'll go into regression if she's forced to be in the same room as like that.
Exactly. That's right. And it's interesting that in family law, in the family procedure, mediation is not mandatory. It's strongly encouraged, but it's not mandatory for reasons that relate in large part to how common domestic violence is and how many family law cases are characterized by some sort of trauma or at very least a power imbalance between the parties. Right? Because the idea is that when the parties have this type of traumatic history, and especially when one party has been exerting coercive control over the other, it's not possible for mediation to work. Because mediation kind of requires each party to kind of speak up for itself, and that's not possible in a lot of family law contexts. So this this comes into play here, right? That principle is brought up, but it doesn't actually end up carrying the day here. So the judge here, Justice Keightley, this is a brand new rule. She kind of doesn't know what to do. She like went above and beyond, and that she actually went out and did her own research and found all these previous exemption cases, and to figure out why exemptions are granted, right? Because we have this rule 24.1.05 saying that in principle you can get an exemption for mediation, but the rules are not helpful in that they don't tell us what might justify that exemption. So Justice Keightley finds that the number one reason why you can get an exemption from mandatory mediation is that you have basically mediated already. In particular, if it's a related action, right? Sometimes, especially in commercial litigation, there will be 4 or 5 different lawsuits going back and forth between effectively the same parties. And if they've already had a mediation in one of those, and it didn't work, it's considered a waste of time to make them do it again in another action when the basic dispute is the same. And so that's not the case here. And what does she conclude? What does the judge conclude about the concerns of the defendant vis-a-vis mandatory mediation? Exactly, that's right. So it all kind of plays out in paragraph 19, right, where she's saying she doesn't dismiss these concerns, but the point is that mediation is flexible enough to deal with, to respond to them, right? So mediation, all that's necessary for it to be a mediation is that there be a neutral third party who assists the parties in seeking a consensual resolution. And that leaves the door open to a mediation which is conducted remotely. A mediation can even be conducted like asynchronously, in the sense that the parties kind of send submissions by email to a mediator who then kind of considers them and distributes them to the others. The parties never have to see each other. Mediation can sometimes be conducted by a panel of people. So the point is it's a very versatile form of dispute resolution. And Rule 24.1 does not require a specific version. So it's adaptable in ways that respond to these concerns. And choosing your own mediator. It's not the court telling you who's going to mediate your dispute. You can come up with anyone who is acceptable to both of the parties. So this is a case which basically is here to establish that the consent of the parties is not enough to get you out of mandatory mediation. Right? Throughout this course, we've been looking at the tension between, on the one hand, the principle of party control, right, which is an ancient, well-established idea in civil procedure, that the dispute fundamentally belongs to the parties. And if the parties agree with each other about how they want that dispute to be handled, then we should defer to that. So party control versus increasingly reason the courts find to deviate from that. Whether the parties agree to it or not, or they want out of it, doesn't matter, right? Because the system increasingly is coming to the view that that the parties, letting the parties control everything is going to produce outcomes which have negative effects for others. Because at the end of the day, this is a system we all pay for, right? It's a taxpayer-funded system, and it's also a system which has limited capacity. Right? So there's people waiting. We know that it can take 2 years to schedule a civil trial. And if we let people avoid mandatory mediation just because the parties want to get out of it, then that increases the wait time for everyone else. Okay, so we have that idea, and then we have Rundle and Kruspe. So okay, here we go. So the plaintiff, in this case, right, in Rundle versus Kruspe, the plaintiff wanted to delay the mediation until after the discoveries, right? So they're not saying we don't want it at all. They're just saying let's do this after the mediation, after the discoveries, and that's something the clients will often want to do, right? They'll say, we're willing to settle this at some point, but how can we settle before discoveries have happened? Because we don't know what the facts are, and we don't want to give up too much before we know what the other side's case is. But the rules clearly say in 24.1.09 that it has to happen early. Shall take place within 180 days after the first offense has been filed, unless the court orders otherwise, which would typically be before discoveries happen, especially in case where there's a lot of discovery. So why is this? I mean, why does the system care when mandatory mediation happens? Why not let the parties do it later if they want to show their cards and see the other side's cards in discovery before they do this? Yeah. So it's quite possible, as you say, that as litigation proceeds, like it tends to solidify people in their views and make them more cling to their positions more aggressively the longer they go through this process. So it could avoid that, and also, I mean, the simple question of money, right? Because discovery is the real like money hog in civil litigation. Like the whole thing is expensive, but you know, having a lawyer draft a statement of claim is relatively inexpensive compared to what it costs to have a lawyer sit in a room for a week or two, examining someone for discovery and representing you as you're being examined, right? And going through all these expensive disputes about disclosure of documents and so on. So if we're trying to have mediation to save legal fees, then it would be illogical to place it after the part of the process in which generates most of the costs, which is to say discovery. Okay. Another thing which comes in this case is an interesting thing about the rationale for mediation. Right? So everyone knows mediation, you're trying to settle. But this case helpfully reminds us that a settlement is not the only success outcome of the mediation. The parties can narrow the issues in the dispute, or at very least come away with a better understanding of the other side's position. The mediation can still be considered a success. So mediation sometimes kind of create groundwork for a resolution that does not occur in the mediation, but will occur a week or two down the road. Okay, I think that brings us to the end of mediation. We don't really have time. I think there's, I'll just say in parting before we leave ADR, there's lots of different variants out there. So we talked about arbitration, bilateral negotiation, and mediation. But there's lots of creative ways to resolve disputes, right? So med-arb, anyone ever heard of med-arb? You know what that is?
Yeah, I think you mentioned it in our Access to Justice class last semester, and I think it starts off as, or the person there, the neutral third party, initially will try to conduct a mediation between them, and then if I guess they're unable to come to a solution, then he or she will then impose a solution binding both parties. Exactly,
right? So that's a good one to bear in mind, and there's various other things as well. Read the Adams excerpt if you are interested in learning more about ADR. Okay, any questions on any of that before we talk about class actions? Okay. So we are here in the center of the course, right? So you remember the first part of the course, we talked about the conventional civil action, right? This long winding road that's well established that leads us from pleadings all the way through discovery to trial. And in the second half of the course, we've been looking at all of the alternative routes to justice, which respond to the deficiencies in that, right? And one major shortcoming in the conventional civil action is that no sane person would ever set off down this road unless something really bad has happened to them, right? If you have suffered a minor inconvenience or the loss of a small amount of money, you would not, unless you have a very peculiar, affection for what most people find to be a highly aggravating and draining process, you would not undertake this. So that's not a problem, right? I mean, we don't want people using civil litigation for minor or inconsequential losses. But the problem is that sometimes a defendant will cause a loss which is very large, right? A loss which is worth hundreds of millions of dollars, for example. But that loss, that hundreds of millions of dollars in damages, will be divided among a very, very large group of people, right? And if 100 million people each lose a dollar, something very wrong has happened that the system should be remedying, but it will not be in the interest of any one of those 100 million people to commence a conventional civil action, even in small claims court, because it's not proportionate for them. So that's why, and even if they did, right, if we had that type of widely dispersed loss, even if the victims were motivated to bring the cases, that would require judges to sit through 1,000 or 1,000,000 identical cases, right? Because it's the same damage caused to each, and that would be a waste of judicial resources. So that's why we have class actions, right? One of our alternative detour routes to civil justice. And this is simply a lawsuit in which one party is a class, which is to say a group of persons, individuals, or can also be corporations, who have some sort of common legal interest. Usually if the plaintiff side is a class. Sometimes, and there's actually a big case that came out a couple of weeks ago, there's such a thing as a defendant class action as well. There's a single plaintiff suing a class of defendants. Okay, so I'll show you this class action, which was just resolved this year, in which you were all, or I shouldn't say all, most of you were probably members of the class. Right? And most of you had your personal legal rights at stake in this dispute. So it was brought by a guy named David Hughes, right? Who is the proprietor of a pub called The Poacher. And he, as representative plaintiff, brought this class action suit against the LCBO, the beer store, Sleeman, Molson, and Labatt. Right, all the corporate owners of the beer store. And I can't remember if I sent it to you, but I'll show it to you anyway. So this is how a class action will begin, right? It's a document called a notice of action. So it's got a slightly different name, but it's effectively just a statement of claim, right, of the type you're used to. And what was this about? So he was saying that there was basically a price-fixing conspiracy between the LCBO and the beer store, whereby they carved up the market, and such that like the LCBO would not sell beer in large quantities. You probably know you can't buy 12 or 24 at the LCBO. So the LCBO and the beer store said, okay, you guys keep that part of the market. And then we're not going to compete for the pub market either. So basically, it was a price-fixing conspiracy, right, which is against competition law in Canada. So the essence of this lawsuit was that prices were higher than they otherwise would have been because of this illegal conspiracy to fix prices between the beer store and the LCBO. And so David Hughes brought this. He says, I'm paying more for beer than I otherwise would have, and I'm probably selling less of it than I otherwise would have because the prices were higher. But he brings this claim on behalf of all persons in Canada who purchased beer in Ontario between June 1st, 2000 and the date on which this action is certified as a class proceeding, 2015. Right? So I don't want to, raise any inferences about people's lifestyle habits, but I think probably most of us were members of this class and therefore had our civil rights being asserted, right? Which is weird because, I mean, most people didn't know about this. but it's a reality. In fact, most of us are probably members of multiple classes right now because there are enterprising class action lawyers bringing these things all the time, often for consumer things, right? Like if you ever bought, there's been a lot about like printer ink, and there's a big one against Loblaws for the price of bread. So people are drawn into these classes without knowing about it. Anyone ever received money or something else of value as a result of a class action or a settlement? Okay, a few people, yeah. So sometimes you'll get something in the mail or you'll see a notice and it says if you bought this between this period and this period, go to this website and get your check for 56 cents, or it's often like a pathetically small amount of money, but not always. Okay, so so Mr. Hughes in this case is the representative plaintiff. And what does that mean? That means that his name is on the lawsuit, right? He's up there at the top, in the place where the plaintiff would always be in the statement of claim. And he is the one who instructs the lawyer for the class. And he's also the one who could be liable for costs. We know that a plaintiff can be liable for a cost award to a defendant if the litigation is unsuccessful or if the plaintiff's conduct is otherwise so egregious that the cost system sees fit to compensate the defendant. Okay, so he's the representative plaintiff, but he's doing this on behalf of all these other people. So what you need to know as kind of a principle of the conventional civil action is that this is not a completely different type of lawsuit. The conventional civil action remains at the core of a class action, which is to say that if you bring a class action, you're going to go through all those steps that we're familiar with. There's always going to be pleadings, there's going to be motions, there's going to be discoveries, and then there's going to be a trial. What the class action does is it layers a process above that conventional civil action and a process below. So certification is the distinctive class action procedure which occurs before the conventional civil action even begins. And then settlement approval is the distinct thing that class action law, Class Proceedings Act, requires after the conventional civil action is done, assuming it settles. Okay. So let's look at so we'll look at certification, and then on Thursday we'll get into settlement approval. Readings from the Class Proceedings Act, which governs all class actions in Ontario, and certification, as I said, is the first thing that happens. And certification is where the fight almost always happens in class actions, right? Because the pattern is that defendants will resist certification, will put all their resources into fighting against the certification motion. The certification motion is what makes it into a class action. And then if the certification motion is granted, that is to say if the plaintiff is given the right to advance this on behalf of the class, then settlement very often follows quite quickly. Because from the defendant's point of view, if the plaintiff gets the right to bring something on behalf of the class, they have a big strategic advantage. They can now aggregate damages of many, many people and bring a claim which is a 6- or 7-figure claim instead of just the 3- or 4-figure claim that individual plaintiff might be entitled to get. So this is what people fight about, right? Should it be certified as a class action? And we'll get to Section 5 in a second, but it's worth starting, I think, with Section 6, which gives us reasons why a court shall not refuse to certify a proceeding as a class action, right? So things which should not be impediments to something being recognized as a class. First of all, the fact that the relief claimed includes a claim for damages that would require individual assessment after determination of the common issues. So it is not necessary that all the members of the class suffered exactly the same thing and that their damages are equivalent in monetary value. right? It's possible for one class member to have suffered $10 of damage, another to have suffered $10,000 of damage. That is not a reason to deny certification. Nor is it a bar that the relief claim relates to separate contracts involving different class members. So sometimes there will be consumer class actions involving cell phone contracts or something, right? And the defendant wants to say, well, how can they possibly be a class? I mean, we had a different service contract with each one of these members. That's not a bar to certification. The fact that different remedies are sought for different class members is also not an impediment. Or even the fact that the number of class members or the identity of each class member is not known. That's why Mr. Hughes could bring this, this action on behalf of all of us beer drinkers of Ontario without having to spend any time trying to figure out how many of us there are, let alone figuring out what our names are. We're just all swept into that class. And nor is it even an impediment that the class includes a subclass whose members have claims or defenses that raise common issues not shared by all class members. Right? So Section 6, it sounds like the legislature is really trying to create an expansive remedy here. Right? They want us to be able to use class actions even if there's things, lots of things that distinguish different members of that class from each other. Okay, however, as we'll see, the Supreme Court of Canada has a more restrictive understanding of this in the case of Hollick that makes class actions not quite as open to the world as this legislation may make it suggest, make it seem. Okay, so Hollick. So this is about a charming little spot north of Ontario called the Keel Valley Landfill. Anyone ever been there or smelled it in the area? Yeah, just a couple of people. You don't have to be that close to it to know it's there. I actually went there in grade 5 on a class field trip, and you never forget the smell. Like you can smell it when you shut your eyes. So Mr. Hollick is not a fan, right? And he lives in the area. And he says, it stinks, it makes a racket, the garbage blows onto my property. He basically doesn't like living near a dump. So you know, why a class action though? If Mr. Hollick walks into your office and you're his lawyer and he's never heard of class actions before, and he says, I want to sue the Keel Valley landfill. Why might you want to raise the prospect of a class action? Yes, that's right. It's all about you. You're the lawyer having this conversation with Mr. Hollick. And Mr. Hollick suffered $1,000 or $2,000 of damage from this dump. Your conversation with him about fees, if it's just a normal conventional civil action, will be, okay, I need a $5,000 retainer to start. It's going to cost you $350 an hour. And he walks right out, right? Maybe $5,000 up front and $350 an hour to sue over $2,000 in damages. But if it's a class action, all of a sudden you as a lawyer are saying, okay, if we can turn this into a class, then I'll take 30%, and you know it's 10,000 people, and each of those 10,000 people has suffered $4,000 of damages. All of a sudden the economics work, right? The fact that it's a class and the existence of a contingency fee renders it economical for a lawyer to take that case and advance it, where it would never otherwise be economical to do so in the absence of a class. Okay, so the court is confronted with a certification motion, and they've got to decide what to do. They talk about paragraph 14. They give some props to the legislature for having brought this in. They say it's clear from the legislative history that the act should be construed generously, right? Previously we had this old rule, but now we've got this new legislation with Section 6 that tells us all these things that should not stop us from certifying. It was adopted to give us a procedural tool that was sufficiently refined to allow us to deal efficiently with these things. Because the system has its own reasons for having class actions, right? There's this judicial economy idea that it saves time if we can have common issues resolved together instead of having to have multiple cases about basically the same thing. Okay. An important point about certification comes here at paragraph 16. That this is not, the certification motion is not meant to be a test of the merits of the action, but rather a procedural. This is a procedural motion. Remember the distinction between substantive motions that are about things that happen in the real world and procedural motions that are just about how litigation will occur? Well, certification is a procedural motion. We're not telling it's not about whether Mr. Hollick suffered damages or whether there's some legal defense for the defendant. It's simply about whether this dispute should be handled under the Class Proceedings Act or handled the old-fashioned way. Okay, so let's look at these. Factors. So Section 5, and that's his class, by the way. This is how he defines his class. He hasn't named everyone who's involved, but he's drawn this square on a map, right? He said these are the streets, and everyone who lives within here in the affected period is a member of the class. Okay, so here's Section 5. Under what circumstances should we certify a class action? So first of all, the courts, the pleadings have to disclose a cause of action. Well, that's nothing special. Pleadings that don't disclose a cause of action can be struck out anyway. Secondly, there has to be an identifiable class of 2 or more persons that would be represented. Otherwise, by definition, it's not a class. And it has to be identifiable, so that's why you have to have some rule for saying who's in and who's out. 5 sub 1 sub C, the claims or defenses of the class members have to raise common issues. Again, kind of obvious. If there's nothing that these people have in common, then there's no reason to think of them as a class. Section D, the class has to be the preferable procedure for the resolution of the common issues. So there, this is where the action usually is, right? The preferable procedure test. And so it means we're comparing the class action to all the other things that could happen, the other mechanisms, procedural mechanisms that could be used to resolve this case. Turning to 5 sub 1 sub E, we focus on the representative plaintiff, right? So Mr. Hollick or Hughes or whoever it is coming forward and put their name on that statement of claim. And we scrutinize that person and we say, first of all, would they fairly and adequately represent the class? Are they basically up to the task of being this plaintiff? Do they have a workable plan? So this is a higher level of scrutiny, remember, right? Because usually at the pleading stage, we don't ask whether the plaintiff has a workable plan, right? You just put your statement of claim in, and then the system kind of sits back and lets people, bring their motions and let them have discovery. And if the plaintiff is kind of botching and doesn't have a workable plan, then eventually they'll lose. But in a normal civil action, you don't have a court scrutinizing that at an early stage. Here we do, because certification has such important consequences for the strategic balance of power between plaintiff and defendant. We don't grant it unless they have a workable plan. Finally, they cannot have any conflict of interest with the other class members, right? So conflict of interest. So this is kind of, you know a bit about conflict of interest from legal ethics. A conflict of interest is anything that pushes someone away from the loyalty which they ought to have for those that they're representing or working for, right? So what kind of circumstances might create a conflict of interest for a representative plaintiff? What facts, if you're the defendant, might you flag to say, well, this is a reason why Hollick, even if this is a certifiable class action, these are reasons why this Hollick dude should not be the representative plaintiff. Right, okay. So things that could make that representative plaintiff refuse to settle when most of the members want them to settle. That could happen, yeah. Like especially, just having, like if Hollick just has a bigger, let's say he's got like a house, he's got more land that's affected by this, or he's closest to the dump, so his damages are higher. that in of itself is not a bar certification, not a conflict of interest, because we know that different people can get different damages. But if he, for example, were like a real like anti-dump zealot, like it's personal, he hates this, he's got like a religious opposition to the whole idea of dumps, then yes, that could make him far more aggressive and less willing to contemplate settlement, because he's going to be the one who's going to pull the trigger on the settlement on behalf of the class. Yeah, so that could be it. Going the other way, if he has a pecuniary interest in the defendant, if his wife is the CEO of the dump or something, right? Then that could make him create a conflict in the other direction, right? Make it kind of soft pedal his representation and not be willing to go hard enough and insist on enough in order to make it work, in order to represent the class fairly. Okay, so that's what the Act says, and on Thursday we'll get to the exciting conclusion where we find out what the Supreme Court of Canada does with this legislation, and you won't believe it. So stay tuned.